Thank you so much for tuning in to today's panel on intellectual property and artificial intelligence. My name is Ekene Chukwukeke, and I'm a fellow with the Internet Law and Policy Foundry, a passionate collective of early to mid-career law and policy innovators who have a deep interest in technology. With me here today to discuss this hot topic are three amazing experts in intellectual property and emerging technology. We have Juyeon Han to my left. Juyeon is a partner at Eisenberg and Baum LLP, a law firm in New York City. She is in the Artificial Intelligence Fairness and Data Privacy Practice Group. We also have Elena Gurevich. She is the Director of Development at the Center for Art Law and founder EG Legal Services. And last but not least is Franklin Graves. Franklin is Technology Counsel at HCA Healthcare and the brain behind Creator Economy Law, a weekly newsletter on the legal issues surrounding the creator economy, internet creators, and internet platforms. So I'm so excited to get into the conversation today. It promises to be a really engaging one, and we would love your active participation. Share questions for the panelists in the comments, as we'll have some time to answer them later. Cool. So to begin with, IP and AI are very broad terms. We had an introductory AI 101 series 2 weeks ago that's available on the Foundry's LinkedIn page. But for the purpose of our conversation today, like, what is AI? Can we simply explain what it is and what specifically we're talking about today? Franklin.
Yeah. So that's a really great starting point. I'm an advocate for making sure that we clearly define what is artificial intelligence, what is machine learning, what are all these ancillary terms, including like generative AI. What does that mean within the context of the discussion that's being had, the use case that's being considered, the contract that's being reviewed, or in some cases, the litigation that's getting filed. And I think that in a good starting point for people that are just getting into this is to understand artificial intelligence means a lot of different things. I think it's fair to say there's not a one defined term for it. But that being said, there is also in the National Artificial Intelligence Act, there is a definition for artificial intelligence and machine learning. But simplistically, artificial intelligence is a concept that is attempting to have a machine or a computer mimic what a human can do from a thought process or from an action standpoint. And then the subset of that would be particular types of artificial intelligence, which would include machine learning, which is a type of practice of artificial intelligence, where, as we see a lot of in the news, generative AI would fall within the category and bucket of a machine learning technology with neural networks and large language models, all those kind of fun terms that you see thrown around. But ultimately, it falls back to the concept of mimicking human behavior, or mimicking human thought, or mimicking human action.
Thank you. And so today we're going to specifically talking about generative AI, which, as Franklin mentioned, is a subset of AI generally. So how do generative AI tools function, right? Like, can anyone explain that? It feels like magic, but we know it's not. So could you just break it down? Like, how do generative AI tools function? So whether it's like ChatGPT or Midjourney, DALL-E, from like input to output, like, just if we could just break it down to me, like, I'm 5. Okay, Elena.
Yeah, I can do it. So these models basically are sort of inspired by the brain workings of humans, right? So these patterns are called neural networks. So the way generative AI models work is they identify patterns and structures within the existing data that's been fed into them. And that's literally just massive data that's been fed into these models to train them. And then the models are using these patterns to generate new and original content, which sometimes can be infringing on other people's copyright, because obviously all the data that's been scraped from off of the internet is not in public domain, and there are copyright implications with the output.
Thanks, Elena. So at this point, I would then ask, what is copyright? What is IP?
So IP basically refers to creations of the mind, right? Artistic, literary works, inventions, symbols, anything and everything that kind of people are coming up with their creative output, so to speak. And where copyright comes in is it protects the original works of authorship. A song or a painting or any piece of creative and original work created by humans. Yeah, essentially, that's being the operative word these days. Human created.
Human created work. Okay. We're gonna get back to that soon. The human created aspect. So we've defined IP, we've defined copyright, and also AI. And then, like, what do these have in common, right? Because copyright law has existed for such a long time, right? And then generative AI feels very relatively new. And there have been calls for AI to be regulated since November when ChatGPT launched. So some people are saying the government should regulate AI and pass laws for AI, and others are saying government should leave AI alone. And then there's this quote that I love from Professor Pamela Samuelson at UC Berkeley. She says, copyright law is the only law that's already in existence that could bring generative AI systems to their knees. So what does copyright law, which has been around forever, have to do with this seemingly new phenomenon of, generative AI?
If I may just kind of jump in and reflect back on some of the answers that were given by Elena, and some of the ways that we've framed our discussion of AI as well explained by Franklin. I think one of the things that I want to give focus to here for our discussion is that the kind of AI programs that are used for generating artwork and for music and a lot of different artistic works is that while we have these computer programmers or scientists and mathematicians that create the algorithmic apparatus for creating the underlying artwork, that's kind of a distinct issue. There is an apparatus, a machine that allows for artificial intelligence and neural networks to inhere in that machine. And then the output of that is the generated artworks, right? So I just want to clarify that functioning is what is at issue here when it comes to copyrights, because, as we mentioned, there are neural networks that are in the machines that try to emulate the process of thought and intellect of human beings, and then make decisions, and then copy from the inputs that it has seen, it has observed, it has been fed as training data to output something that is seemingly new, so to speak. And in doing that, it's an emulation of a process of a human mind. However, it is not a human mind, because the machine itself is created by human minds, right? By the algorithms that drive it. And certainly humans can set the parameters to give weight to certain kinds of data or to look for other kinds of data in a style of somebody, in a style of whatever artist. But that's the kind of modulation that's done by humans. But then the rest of the process of creating the art is done by not humans, and it's actually done by the computer program itself. And much of that program is not explainable. It doesn't say I took 70% of the data from this particular training set, or I took it from this particular artwork that I've seen to generate this, right? So there's not really a process of explainability, nor is there a way to actually say it was this artwork of Rembrandt that the computer looked at in order to generate this process. So that process in between of the computer generating its own artwork is what is kind of difficult to define when it comes to copyright, because as Elena was saying, copyright as of now, as the Copyright Registration Office has opined, it's only going to protect the rights of human-derived, human-created artworks. And that is very important, because when we talk about rights and intellectual property, a property right is something that belongs to somebody, right? And there is a person who can exercise that right. If there's no person that can exercise that right is futile, right? It's meaningless if you can't exercise it in a practical sense. But the copyright that is currently given is to a human being. So although, there is a program that's made by a human being, there is a art that's not made by a human being. And so there is this great gap where, litigation is now coming to bear, and courts are trying to figure out what to do with that right and who owns that right. So I just wanted to kind of configure that to give us a zoom in focus on the issue.
Thanks so much, Jiyeon. That's definitely helpful, and that sets the tone for the rest of the conversation. So before we get into the process or how the law sees that act of processing, I would like us to talk about the data that the foundational models use to train for the generative AI systems. So is it legal? Because I think ChatGPT pretty much scraped most of the available information on the internet. So is this legal for them to just use available content on the internet for free? Like, is this legal? Is it illegal?
I think I'll take that one. I think it's an interesting question, and one that has been explored a variety of different times, both within the AI context, the generative AI context, or maybe more fairly in the database construction context. But it's also been examined by the Supreme Court, like in the Van Buren case, outside of an AI context. What is, I think, if you're talking about web scraping to build a database or to compile a database, then it begs this question of, are you exceeding the permitted access to a website by going to a website for purposes of extracting the information, the content from that website? And so currently there are a slew of laws that could trigger this, whether it's the CFAA, the Computer Fraud and Abuse Act, or whether it is the terms and conditions that are on the website, or something even on the technical side, if there's a robot.txt, or if there's some other technical mechanism that is put in place, whether it is a login or some other type of firm wall that prevents or intended to prevent somebody not exceeding the scope of their authorization on the website to take information from the website. There's a whole host of scenarios and questions that raise legal issues. But then additionally, outside of the context of just access and the right to access publicly available content, then it begs the question of, okay, then even if you can access that publicly available content, is it still subject to usage rights under copyright law? So just because you can access something doesn't necessarily mean that it's still not subject to copyright law or copyright ownership or concepts of that, or it might even be public domain if it's not subject or eligible for copyright protection. And then moving outside of the IP side, there's also a whole host of privacy considerations. There's a whole host of facial recognition or just individual privately identifiable information. So there's a whole host of issues that can come from compiling databases, whether it's databases of images or whether it's database of just text or some combination of that. All those types of questions are swirling. Another case that's important to look at is the HiQ case that was LinkedIn was involved in that, which I think is important to recognize as the parent company is Microsoft in that situation. They were being very protective of a third-party unaffiliated company, unaffiliated being a loose term there because they did have a business relationship to a degree, coming in and extracting publicly accessible profile information of users of LinkedIn and then compiling their own database. LinkedIn obviously didn't like that. So the whole slew of issues I just explained were all brought up in that case, as well as, like I mentioned, the Van Buren case. There's ongoing cases right now that look at that in terms of what is the legality of the web scraping that's happening. And then one other nuanced thing is, for example, the Lion database. That one is a compilation of links to where the images are stored on the internet. So a storage locker or a server or something like that. It's not actually, when you download that database, you're not actually downloading the images or the content and making copies of it. You're doing that on your own by going in and pulling and extracting that information, at which point then are you making a copy that would be subject to copyright laws? So those are kind of some of the main issues that are swirling around in this space on the scraping component of it.
Yeah, thanks, Franklin. And from the HiQ and LinkedIn case, I believe what the court said there was that web scraping itself is not technically illegal, but then it could still violate other laws potentially, including copyrights. So while we're considering that there is the potential that there could be a copyright violation, potentially, are there any defenses that they could also potentially rely on, right? These generative AI companies in scraping the internet for content. Elena, do you want to go, or Julian?
Sure.
Oh,
Um,
go ahead, Ellen.
No, I mean, I can start. Well, they can argue that it's for just purely research and non-profit purposes, right? So we will not derive any profit off of the use of this scraped information. For example, in the EU, there's the text and data mining exemptions, right? So all these huge companies obviously are training those models by feeding the data that's been scraped, publicly available, some of it, like I already mentioned, not. So, and it's basically, they're getting this information for free. And their argument will be, so we've input like so much money into this, we train those models, we build the infrastructure, right? All the computers, the GPUs and everything that's needed to maintain this model, right, working. So their argument will be essentially, so why would we offer the service for free, right? So, and it's kind of just, it can be argued both ways, I would say, but the main thing I would stress that kind of just when the data scraping is involved, so what purposes does it serve, like in the end, right? So will it be used again in commercial purposes, or what type of data was used in training the model? And obviously there are personal data implications, privacy, and like Franklin and Julian said, copyright implications. So it's very, again, this is such a great area, and kind of just everything is just up in the air, and everybody's just on standby for any legal resolution with all the pending cases around us, you know, kind of just, yeah, it's very interesting. The favorite lawyer's response is usually like, it depends. So in everywhere you go, it's like, it depends on certain facts and certain particular aspects of a case. So yeah, it's very interesting to see where it's gonna go.
Thanks, Elena. And Julian, before you respond, as the litigator in the room, I know that there was the Google Books case a while ago where Google was sued because they were not scraping, they were scanning books that were publicly available, books that are available on the internet, to make them publicly available as Google Books, to make excerpts of them available. And Google was able to rely on the fair use defense in that case. I think the court found their use transformative. So do you think that today in 2023, with what companies like ChatGPT are doing, do you think there's a good chance they'll be able to rely on the Google Books defense, like fair use, like Google Books did, or is it kind of different?
That's a really good question. And I also just wanted to piggyback on what Franklin and Elena said with regard to all these different lawsuits that try to give guidance. And just one more thing to add there is how difficult it is from the standpoint of a plaintiff who is trying to assert copyrights in these scenarios, because even in an open source, you know, kind of a scheme, and there are licenses built in, right? Open source licensees can dictate what can be used and for what purposes and what have you, right? But even let's say that the person holding the copyright can take advantage of all of that. When it comes to actual enforcement of that in litigation setting, the plaintiff has to show that the kind of artworks that they had thrown out there in an open source repository was the one that was actually used, and then say that that's why my copyright had been infringed. And that's extremely difficult to show because you don't have access to the machine, right? The person holding the copyright. So they can't show And this is like as everyone knows here, it's a standing issue. You can't show injury in fact, because you're just out there assuming it looks like it's my work that had been fed to the machine, but I don't know because I didn't feed the machine. So when I ask the people that I'm suing, did you feed the machine? Are they going to say yes? No, right? Because they also don't know, right? It's a machine process on its own. So then you ask the machine, and the machine's like basically a 3-year-old baby. They don't remember, they don't know, right? So the enforcement is also what is a big hurdle here. And perhaps without the courts intervening to an assertive way of saying, we're going to do an in-camera review of what went into the data and when, or, try to, audit that process, it would be very difficult for plaintiffs to show, which is what happened in the GitHub case, right? Because standing was what really came into the issue of the decision by the court. And although the artist could ask for injunctive relief to say, well, I don't know if my artwork had been used, but I don't want it to be used. So can you order it not to be used? That injunctive relief only goes so far, because let's say somebody violated the injunctive relief order. How are they then going to show that, right? It runs into the same problem. So I think there are practical issues on top of the defenses, the fair use defenses that defendants can use to further protect the defendant's positions, which are, they're all positions. I'm not saying one way or another that one is stronger. It's something that the courts will decide. But then going on to the question that you mentioned, Ekene, I think the Google Books issue and possibly the potential ChatGPT issue about fair use is something that's going to be really stretched. We recently saw the Supreme Court case in Warhol where, the fair use doctrine, according to the Supreme Court, will apply will apply to protect the interests of the original copyright holder, right? But it'll also become cut up and chopped up in ways to say, well, in that case, the fact-specific nature of looking at fair use doctrine was that, there was profits derived, very blatantly there. And it's very similar. And, there's also a lot of communications going back and forth about the blatant fact that those two artworks were interconnected. Whereas in this scenario of AI, you don't have that nexus to show, whether my artwork that was infringed allegedly is in any way, related to the other artwork that's coming out as a result. So, but the point is that fair use doctrine is a very fact-specific issue. And so naturally, it'll be like a case-by-case scenario where courts are going to have to sit down and decide. And I'm not sure that we have the, shame on me, but I'm not sure that court systems are ready to handle millions of these cases and look at, okay, does this look like the computer copied this work or not, right? So there's a more of a logistical, judicial economy issue that is kind of glaring here. So, those are all more complications that come to the case-specific standard for fair use doctrine determinations.
And I would just add, I think Kimberly, I saw in the comments, mentioned the number of cases against OpenAI. And to Gion's point, I think there's not very many artists that can be out there and pinpoint exactly this is proof that my particular work was part of the training data that informed this output. But I think we're seeing in the Getty image case against OpenAI, there are artifacts that override that are so prominent in the training material that it's like a watermark, like the Getty image watermark, that it's going to pop up and crop up in those types of images if certain triggers are met. Again, through however the machine learning model or the model that's running it, large language model, whatever it is, how that's structured. We are seeing, I think it's going back to another discussion we had about how do you properly maybe pay artists for their work that are being used to train these models. Adobe Firefly is a good example of that, but I think there's still questions from the art community, photographer community. How is that managed? Because it's a black box. It's very hard to understand how the training materials impact the final output and which ones in particular were responsible for that. And I think we all examine that and have been a part of that through like a Google CAPTCHA, where despite what it wants me to believe that I'm not human, sometimes you get it wrong, but we're training an algorithm in that way. And so I pinpoint that as an example of having a picture of a dog is very important to be able to train a model of what a dog is not as well, by having pictures of bridges, by having these other influences that can help a model understand, using a human terminology there, of what something is and what something isn't in a photograph, for example. But yeah, I just wanted to highlight what Kimberly put in the comments too about there's a lot of litigation going on with OpenAI and how they took the approach here.
I also just kind of quickly wanted to add to Jayong's point about the plaintiffs and the hurdles that they're facing, right? When it comes to generative AI infringement litigation. So it's not even like the legal hurdles, but technical hurdles as well. For example, right, the artist wants the platform to take down her artwork. For example, she is convinced that her artwork, the model was trained on the artwork, right? And there's no, as far as I know, and I've read quite a bit of research on that, there's no way it can be done as of today. I mean, you will have to retrain the model in order to do that, in order to achieve that. And even that is not the likely outcome. So pretty much there's no way, once the model was trained on that particular image, if you are certain that it was used in training, right? There's no way to remove that particular image without just kind of just unwinding like the whole system, right? You have to retrain the whole model. There's millions of dollars and time, obviously, and everything. So it's not even, there's no easy way out, even if they wanted to, right? If they wanted to comply, they're like, yeah, okay, sure, we'll remove your content just right away, and there'll be no more training on your art, right? They can't even do that. So,
but I think an important thing also to recognize is some services are implementing technical measures to prevent an output from being, to use a copyright term, substantially similar to any of the training materials. And so that is one practical implementation we're seeing to alleviate some of the concerns and reduce risk on what an output and how an end user is using the tool. But again, it still doesn't directly address that first question of the copy is being made to train the model and to build and power the whole process.
Thanks, guys. And now I think it would be a good time to talk about the models themselves, because in the stability AI, in the case against Stable Diffusion brought by Sarah Anderson and a number of other artists, they're making the argument that, as we explained earlier, or as Elena alluded to, that they're training these models are being trained on a lot of data, and then they kind of like think back to that and they can just copy or create like a collage. So they're trying to make this argument that this machine has this endless memory, and then it makes like a collage of sorts, you know, to create the new art. But then on the other hand, for people on the Stable Diffusion side, people are saying, well, that's not how the machine works, right? The machine isn't necessarily going to pick this element and that element. It's more like the machine has been taught how to think, and it is thinking. So the machine isn't copying from memory. It's really just thinking like someone that has been trained, right, in a certain art. So just from your experience, like with litigation, observation of these cases, obviously we can't speculate and say we know what's going to happen, but how much of this is going to be decided based on the operation of the tech itself, if that makes sense? Like, are the courts going to look at how does this machine work and try to apply the law to that, or they'll be considering the other public policy reasons that you've already mentioned, which is the fact that it will be really, really hard to undo the, you know, the system or to retrain these models because they've already been trained.
Yeah, I mean, I guess to reframe your question for the court, I think you're asking the court, look, we created this machine that's going to think on its own. And then whatever is observed is going to be interpreted as some new sort of inspiration for the machine. And how is that, ever a copying work, right? If we set that standard so high and we apply it to humans, then, the policy that you're referring to, which is it's going to stifle humans from creating any art. Because, I mean, if we think about it, like if I were to draw something of this, this apparatus that I have here, and I drew it, I can claim copyright, right? And it doesn't have to be like, oh, I interpreted this object into like some super fashionable work. I mean, it doesn't take a lot for a right to be copyrighted at the moment. But if we're imposing a super high standard on machines, then that is a problem for stifling creativity issues, right? So there is definitely that issue that's glaring. Do we consider these machines that are able to have their own neural networks and say that they've interpreted data on their own, and then allow them to go through a very low threshold of copyright on their own? Or do we say, these machines are merely just outputting whatever was input, because if there had been no input, there would be no output, right? I think it's actually a psychological issue. I'm very curious to know what would come out of such argument, but it's such a metaphysical issue as well.
Well, thanks to these generative AI tools, anybody can be an artist today, right? So just by giving a prompt, you could write a book with ChatGPT, you could create a painting of an apparatus or anything you want. And on the bright side, some people are actually creating amazing art today, or being able to do more than they would have been if they didn't have these tools. Elena, you mentioned this earlier, that the Copyright Office said, has come out to say that for copyright to be in a work to be protected, like a property right also, as Julian explained earlier, like it has to be held by a human being, right? So as it is now, a human being, to have copyright, it has to be created by a human being. But then what happens when generative AI output infringes, right? So who do we think should be held responsible if, a human being prompted the creation of that, but then they don't actually own the property right in that infringing work?
So when it comes to the outputs, right? The question is who owns them, and that might depend on the platform, right? The person is using, and you have to look to the terms and conditions of the platform. Some platforms are freely granting all the rights in the output to the users, and in that case, the work is yours. You can do whatever you want with it, and sort of the platform is just transferring all the liability from them to the user. Some platforms are not doing this, and again, it's gonna depend on it's a case-by-case basis, I would say, as well. But the U.S. Copyright Office, and everybody here is aware of this, obviously, has been one of the main driving forces of kind of just making things a little bit more clear for us all, where the generative AI and copyright law stand on it. And it's been very helpful, kind of just make the waters less muddy, I would say, right? And so where the U.S. Copyright Office stands as of today is the works that were generated by AI are not to be copyrighted on their own, right? And I'm referring obviously to Chris Kashtanov's case. So in the case of Chris Kashtanova, they created the work called Zarya of the Dawn. It's a graphic novel, and they used generative AI to create the images, and they filed the work to be they filed for copyright registration to the U.S. Copyright Office. And in the beginning, the work was registered and given copyright, but when the U.S. Copyright Office became aware of the fact that the images were AI generated, they canceled the registration, and then they issued their guidance on that, saying in the end the U.S. Copyright Office registered the novel as a whole, right? And the arrangement of the images in the work, but not the images themselves. Like the image that was AI generated cannot be copyrighted by itself on its own, right? Only the compilation of images. So, and that's kind of just where we stand today. If I use DALL-E or Stable Diffusion to generate an image, and I go to US Copyright Office and be like, let's do this, let's register, and they won't be giving me any copyright in that. So anybody will be free to use my work because there was not sufficient original and creative input from me as a human being, according to the US Copyright Office. So where we stand today. I mean, in my opinion, might not be a very popular one, but I think like if an input, like if the prompt would be creative and sufficient enough, long enough, kind of just you've been thinking so much about this, and just it kind of just captures everything, whatever you had in your head, like your idea of the image you want to see. I think it could be copyrighted. The output of that. So, but again, I'm not the US Copyright Office, so I can't speak for them. But the fun fact, and everybody's aware again of that, probably, that the US Copyright Office mentioned that while the images can be copyright, but the prompt itself might be. So again, they are not aware that any prompt were kind of just somebody filed for US copyright registration for a prompt, but maybe somebody should, and we'll see where it's going to go. We need more cases like that. We need more people kind of just barging in and filing their work and just kind of, bringing some fresh ideas and fresh conversations into this. So I think it's very important.
And I would probably push back a little bit and disagree to an extent.
Please.
In terms of that question of the human authorship element, because yes, I certainly agree with the fact that prompt engineering, that whole process of learning how a tool or a system works is to a degree, there's a level of artistic or technical skill required. And so the Copyright Office, like we just said yesterday on a call, did acknowledge that. And although they're not aware of a use case right now or a submission for registration of a prompt, theoretically, it could be subject to copyright protection for the prompt itself. But I think one of the bigger issues that I'm still seeing is the lack of control, kind of like what we've been talking about up until this point, the lack of control over the AI tool or the system of tools that combine together power a generative AI tool. There's missing that ability to really understand how the output is going to work and how what you're going to get on the other side. And so that's where like examples of like the Raya of the Dawn with Chris is they used the prompt included the name of Zendaya, an actress, and it was because of the fact of in order to get an output that maintained the same look of a character consistently enough to have different panes or have different images, you have to have some reference. Otherwise, you have no control over the tool. And I think that that's the same case in some of the newer registrations that are being pursued as well. And that's what the Copyright Office has been telling us is from their standpoint, you lose that human creation, that human authorship in the process along the way of using a tool like that, because you give that up. You're then passing that on to a machine. And again, that's very specific to certain types of text to image or prompt-based machines, but that's kind of the alternate take, I would say, on it.
Ekene, I just wanted to put a point out there. I think what Franklin says is very informative in terms of the ability to control. Right now, the ability to control doesn't belong to the regulators. It doesn't belong to the owners of the copyrighted artwork. So in line with that, I was just looking at the chat where I think this is a really interesting question by, I'm looking at the chat, Kimberly Wright. It's talking about perhaps creating a new kind of art market, that is based upon this principle of AI generated art. And I think that's where control could come in, because there are consumers that drive the market and thus control what the supply and demand is. And that's how, in some ways, the pricing and the value of artworks will come forth. And the value is essential to determining what is a property right, because we can say intellectual property, I own this thing, but if the public doesn't see any value to it, right, whatever I generated from the machine, then I'm going to be ending up with zero money, right? And so the value of a right is also very interconnected with what the art market demands. And what the art market demands is actually something that can be controlled by individual consumers and art aficionados and collectors and such. In doing that, though, in order to hijack, a piece of artwork and make that more valuable than others, I think marketing tools come in, right? And when we say, look, here is a jug, that emulates Picasso, it doesn't at all. But if I were to market it in that way, then I necessarily have to reference somebody that is of value, an artist that is of value. Even in a machine learning process, I have to say, hey, this artwork, I put it into the machine and it's like a Rembrandt, right? And then that might give it superiority in the market. But doing that kind of gives more of an anchor to say, hey, you marketed this and you use something as a reference. So maybe it's in the marketing tools that we can also look to when we look at infringement, not just about copyright, but it can be a consumer protection issue after all. And this goes to the same quote that you mentioned, Ekene, about is copyright the only thing that can bring down machines to their knees? I think no, I think the art market can actually do that, because that's where they value whether a machine-based art is going to be of something that we consider valuable as a property right or not, right? So that's what I wanted to add there.
Thank you. Thank you so much.
I just, again, quickly wanted to add, like, I totally agree. The US copyright law is sort of notoriously market-driven, right? It tends to more protect artists' economic rights versus in the EU, right? And the UK, it's more on the moral rights side of things, right? And it's funny how the recent case of the artist Prince, right? So he used a few Instagram images of some random people he just commented under, and he just took snapshots of those images with his comments underneath and put them in a show, in a gallery. He printed them on large canvases and it looked marvelous with his comments below the image. And the show was a success, and he ended up selling, obviously it's Prince, he ended up selling his works for like 50K a piece, versus the people with the original images, the faces of these images, right? They were just there on Instagram and they got nothing. And sort of like in just kind of their move was they created their own sort of auction of those images that they'd taken, this very same images, and they commented, but these images were selling for like, I don't know, tens of dollars, right? So again, it's like you said, Jayon, the market demand, right? What name you gonna slap on that piece of art in particular, right? I can take selfies all day long and put them on Instagram, but it's just me. Nobody cares about me, right? So the moment Prince takes my image, puts it in a gallery, suddenly my face will be worth much, much more. But who's gonna generate like all the profit, right? Who's gonna get all the profit off of my face? Not me. So again, it's just kind of just going away from our AI topic, but still, it's still very, very fascinating how this whole market thing works. And it's just, sometimes it's not very, I would say, fair.
Thanks, Elena. Thank you. So which will bring me to the next question, which is, so how are artists, we've already alluded to this a bit, but how are artists responding? How are companies adapting to the in-between place we are right now. So we don't have any decisions just yet resolving these pertinent issues. So how are artists responding, and how are these companies as well adjusting their stance to accommodate people's concerns?
Just, on the one hand, I think artists are glad that there are tools that alleviate some of their labor, when it comes to generating artwork, when it also comes to generating like animation from one piece of art. I mean, that can take a tremendous amount of resources and manpower if you were to do it traditionally just by hand. But now that, there are ways to generate this, it could be of a way to alleviate the labor of artists. But at the same time, that means that if you're using AI tools just as tools, not in and of itself an artwork, it's something that I think artists are adapting to quickly and kind of welcoming as a tool. But when it comes to that, replacing the originality of the artist's own artworks, I think there's sufficient pushback about it. I'd be very interested to hear more from the ground if anyone has opinions about that as an artist or as a creator.
I just want to say, sometimes I have this habit of kind of just diving deep into Discord and Reddit and just kind of, feeling, like you said, the ground, talking to artists, kind of just subtly polling people. So what's your take on this and that? And
web scraping, Elena? You're web scraping for opinions?
I would call it more like intellectual poaching. But yeah, the artist community has been just formed by that. I would say people are so vastly polarized on this subject, and it's been very, very sort of interesting to see that people are clashing over that. Some artists are embracing the AI and they are just kind of just immersed in that, and they're using that for their work every day. But on a different side, the artists are totally anti-AI, and they're like, just let's ban the AI just altogether and just we'll be better off, And obviously the artistic communities, I would say, snobbish take on themselves, right? So like anyone who is not skilled enough to be an artist, to be called himself an artist, cannot call himself an AI artist. They're calling these people AI users, sort of like you didn't do enough to kind of cross this line to be called an artist. So which is like very, very interesting, if you ask me. So the sentiment essentially is, on the one side, is just let's do it. It's gonna make our work easier. Some of the artists are very, very confident they'll be keeping their jobs, because still what clients are going for is sort of their creative ideas, right? Some artists are saying, so when the client comes to me, the only thing they have is just like a name of a project. That's it. And when they come to me, I work with them together. We work collaboratively on the project. So from that word, the name of the project, kind of like everything grows. The images, the design, the concept, right? And the argument there is the AI can't do that. So usually when I'm about to use DALL-E or Stable Diffusion or any other platform, right? I already have an idea in my head. I already have a prompt. I already have something in my head that's just will generate an output, an image. I already sort of have this preconceived notion of something. But the argument on their side is, my clients come here, they have this name, they have nothing. They want me to kind of help them to be creative. So, and that's what AI is not capable of doing at the moment. The other side is just, let's ban it altogether. We are better off of it. And the funny thing is, a lot of the people just judging by the comments, they're not even aware of how this technology works. Some people are like, let's ban AI. We don't need AI at all. Let's use YouTube. I like YouTube. I like how it works. But YouTube uses literally AI every day, like the algorithms, right? So how what videos you would like to watch. They're analyzing and they're doing this, they're doing that. AI has been involved in our lives for a very long period of time, which is funny because most of the people are not aware of that. So again, I think education is important on that matter, and critical thinking is more important than ever today. So it's just, yeah, it's been a very, very interesting debate on there.
And I would caution, from my standpoint, I would caution against kind of this concept. I think what was mentioned earlier about the labor involved. I think that it's this concept of fast tracking the creation process, and that's something I think that we've dealt with as creatives for decades, for hundreds of years. There are always new tools, there are always new methodologies that can be used to create something. And so, like, to borrow from like copyright, it's like the sweat of the brow theory. Is there sufficient effort involved? And I think that can change from use case to use case. And so, for example, like on like when we made a switch and computer animation came about, arguably it's easier because you're not having to frame by frame paint or draw a character's movements. But in reality, there's a swap there of what the work involved is. It's the model creation, it's the programming that goes into it, the mathematics involved, and all the physics and all that. And another example is like Adobe Character Animator. If you have a puppet, you can put a puppet in Adobe Character Animator and use your webcam, and it will do facial recognition and body recognition to animate the character for you. That's what a lot of virtual YouTubers or VTubers use for their avatars. It's this question of, okay, well, are we looking at it from a human labor standpoint, or are we looking at it from the creativity behind how these tools are used and how they're implemented? And then the other distinction here too is, I think from what I'm seeing, is the ethics behind it. I think there's a big call for artists, or from artists to other artists, and artists to big companies, tech companies, and outside of the tech sphere, just general companies, to ethically and sustainably source the training materials in a way that, if the use case is going to be to have a generative AI tool that competes with those artists, making sure they're fairly compensated. If it's something that's like on the security side, if it's a model being developed to train and have security footage automatically reviewed to identify harmful objects or something like that, does that really compete with an artist who is, or a photographer, and the output that might be very similar, and supplement a license for their work if somebody's using that to generate an image for their website, and instead of using a stock photography company, that's a missed license. So I think the use case really comes about in connection with how the training materials are gathered, and whether there is appropriate payment or permission of some kind from the artist. So that's kind of what I'm saying. But I think in reality, I think we're moving to a place where it's going to be impossible to not have access to these tools, whether it's Microsoft and Google putting them in everything from Office 365 or Microsoft 365 online and all that, or just generally the expectation is that workloads have to get faster because generative AI is out there and it can make something more streamlined and something achieved more quickly. I think all of those are considerations, but I think that's where we don't have time for it today. But that's where the ethical considerations and kind of the accountability considerations come when it comes to a policy discussion of AI.
Awesome. So I'm just going to go to some questions we have in the comments. So from Ali Logmani, he's asking if the debates mentioned here can be applied to expertise across different domains. So I guess Ali is asking if, like, the arguments we're making here for and against, if they could be applied to other domains, maybe privacy, just other expertise across different domains, if anyone wants to take a stab at that.
I don't know if I'm understanding Ali's question in full. I hope I am, but just how Ekene phrased it makes me think about, when facial recognition technology was developed, right, with all its idiosyncratic problems on its own, right? It was developed with the contribution of more than several billion faces of photographs that consumers had put out there on social media and what have you. And there was a great controversy about how the use of people's faces that they had put out there to develop, a facial recognition technology, whether that's fair or not, whether it infringes, perhaps the biometric privacy issues and things like that. And maybe that's a kind of a transferal of one domain to another when we talk about art, because when we talk about artworks, right, surely the moral rights aspects that's discussed more pertinently in European countries kind of have this notion that in a person's original artwork inheres a person's spirit, the artist's spirit and personality is there. And so when you extract, a bunch of people's, personalities and, spiritual aspects, moral aspects of the artwork, isn't that kind of the same kind of controversy of taking a person's biometric profile and developing technology that's going to be used for something that person doesn't even know about, right? So I think there is kind of a domain to domain transference of that issue. But the other thing that I was thinking about when I heard Ali's question was, is there a difference in, artworks, visual artworks versus music or, videography or cinematography? And I think, there are differences just in terms of what the AI generated artwork is primarily kind of replacing, right? Because when, again, AI generated artwork can be used as a tool. For example, a musician can easily use some kind of soundtracks that'll be better fitting for their own musical instrument, for example, as a backing track, to assist in the performance of that person's performance. And in that way, there are domains that make AI generated tools more of a tool to serve the original purpose that the artwork has. But then there are others, like I think animation is a very good one that is brought up by Franklin, that kind of has its own spurring motions and has its own way of conducting itself, such that it requires more neural networks of the machine on its own, and thereby replaces more of the human-driven process. And maybe that's the distinction between domains. Some are more prone to replacing originality with machines, and others are more prone to using machines as an assistive device to expanding on an artist's originality. So that's what I think I would say about the domains.
And I think we're seeing, as Elena mentioned really well, I think YouTube is a great example right now, because for decades, not decades, for probably about a decade, I even have been using like their subtitle feature. Like you upload a video and it is a natural language processing that automatically generates subtitles. That benefits people that need the accessibility stamp from an accessibility standpoint, but it also benefited me because I could use that tool to download the SRT file and take that and use it elsewhere, or generate a blog post from it that I embed the video into. So I think AI is augmenting and assisting creators to fast track and help them get different pieces of content that all stem from the original content. And I saw somebody mention a question about translations. And I think that's a great example, because the Copyright Office mentioned that yesterday. They wouldn't, if a translation of a work is done entirely by AI, they wouldn't permit registration of that because it doesn't have sufficient human authorship. And sorry, just to backtrack, copyright law does recognize translations as a derivative work or as a protectable work separate from the original. But in this case, they're saying it's not necessary to even recognize an AI translation, because the original creator has protection over derivative works if they just register the original. So if they register the original in German and they make an English translation or a French translation, if those are using AI, those are infringed upon. They can say, well, you're infringing on the original German version. And so in that sense, you have protection still available to you.
Thank you. And Kimberly has a relevant comment here. She said, great example to Franklin. She said those classic pre-1950 cartoons took hundreds of humans to draw repetitive animations, not the best use of an artist's skills. So I think there's definitely some consensus here that AI augments some artists' work, while it may threaten other artists' work, like with writers, as we're seeing with the writer's strike. There's a question from Elizabeth.
Sorry, just real fast. I want to
yeah.
clarify there. I think it's somewhat demeaning to say that work of those character animators back in the day was repetitive or not artistic, and maybe that's not what they were saying. But I just want to clarify, since it's being recorded, that is. I fundamentally disagree with that. I think that there are animators out there that it is an art form. I think anyone in the anime space would disagree with that as well. I think there's a lot of creativity that can go into that. And I think, again, it's a pendulum. There are pump and dump, if you want to call it that, type animation studios that maybe it is kind of just reusing frames, reusing stuff to just get something out there. But I think generally everything is highly analyzed. You can highly analyze everything. And I don't want to get into a debate of demeaning or what might be considered creative for one artist.
Yeah. Okay, thanks for clarifying. I don't think she meant that at all.
Right. But
I think, just like a side note, with the new Spider-Man movie, there was this particular scene where all the Spider-Men were chasing Miles Morales, and that reportedly took 4 years, right, to animate that particular sequence. And I saw a number of like artists just commenting about the fact that, you know, AI could make that part faster. So it's just that. So I think maybe it's more about the length of time that it takes. So not that it's obviously not demeaning that it takes that long to produce good work. It's just AI just definitely augments and makes the process faster. So I think that's what Kimberly meant. Thanks for clarifying. And then Elizabeth had a question here about, sorry guys, we're wrapping up soon. Do you think in the case of artists that used to not care much about copyright in the past, they will now make it a priority because of AI? And how expensive and accessible is it to copyright your work?
If I may, I will address that question with a closing remark and of my own. I think that's a really relevant policy consideration, which I think needs not be lost here in this debate. I think the debate here looks like it's about human versus AI, but I think it's actually about human versus humans who can use AI to their advantage versus humans who cannot use AI to their advantage. And, you know, for example, we think that use of AI, as Kimberly mentioned, could maybe bring the barriers down, you know, for an emerging artist to get into an art market and put themselves out there using the tools of AI and all of that. But a lot of times that's not what happens on a macro level. I think what happens now is that AI is being used to kind of enrich the more wealthier companies and bring down the costs of artworks being generated and do it in a tremendously fast speed and control the machines and what have you. So when it comes to what is the general effect on the market and of artists who are emerging, who are trying to get themselves out there, I think the result is the same with or without AI. It's hard for artists to get into the market and compete against big companies who used to, you know, hire like 5,000 labor artists to generate, you know, a film or an animation versus now using, you know, machines to do that. And the result is that emerging artists don't have the means to do that. It's the same. So I don't think that it's a human versus AI issue. On a policy level, it's about how can we spur more creativity from emerging artists, individual artists, to make more original artworks and pay them fairly. And I think that the human AI debate, although it's very complicated in all its technical uses, should really squarely address that and make policies and laws that conform to increasing individual artists to be able to do the same.
Thank you, guys. There are a few more questions in the comments, but we are at time. It's 2:05. So I want to say thank you on behalf of the Internet Law and Policy Foundry. Thank you to Franklin, Elena, and Julian for their time. And I will just give you the opportunity to leave your final closing remarks. One thing people should take away from this conversation about IP and AI.
So I'll go first, I guess. So my takeaway would be there's been a tremendous surge in the interest about AI, right? There's been hot topics for months, and people, for the most part, at least the people I've interacted with, for the most part, they tend to, I would say, think of the AI as this existential threat, right? To the point they make it almost sentient, right? And I think that's a very, very bad approach, and we need to stay focused. We need to remember that we have the agency. AI is just still, as of today, we'll talk about it in a month, maybe things will change. It's just a tool, and there's no way the robots are taking over and all that fun stuff, the fun Hollywood stuff. So we need to be just active in the space. People need to educate themselves. People need to talk to other people who know about this stuff, you know. It just, you have to be very, very thoughtful about it, because literally hundreds of new AI models and just startups are emerging every week. New tools are being deployed every day, like tens of them, hundreds of them every week. So, and it's very, very, very important for people not to rush into that. Just people tend to kind of just, you know, jump into that without giving it a second thought. But there will always be privacy concerns, right? Personal information, some sensitive information if it's a corporation or a business. So people need to be very, 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 very thoughtful when they adopt and these technologies in their everyday lives and their work life, especially.
Yeah, I would say my takeaway builds upon what was just said. Education is, of course, a very important component of all of this, making sure that you're educated, people listening, I myself, like she said, like Elena just said, like next month, there's gonna be something new. We have to learn it. I have to learn about it, dissect it. I would add to that, now is a time that policy is being crafted on this. We have the EU AI Act that's underway, but even especially in the US, like the Copyright Office just had listening sessions. There's opportunities with the USPTO on the patent and trademark side to give feedback. Voice your opinions, write about it, submit your questions or concerns to the Copyright Office or the Patent and Trademark Office. They want to listen. Your local Congress people, they want to listen. You have a voice, and I would just want to encourage people to use it. But just again, as we've been talking about, making sure that you're coming at it from an educated perspective, but also sharing your unique perspective. We all have our own use cases. We all have our own backgrounds and kind of understandings of how this technology impacts us individually, or the companies that we work for, or that we own, or that we run ourselves. So that's my takeaway is now is the time to voice your opinion. Now is the time to get out there and submit comments.
Julian, any more?
No, that was my closing.
Thank you, guys. And my takeaway from all your brilliant submissions is that copyright could have an impact on the way generative AI system works and the output of them, but then it's not the only thing, right? We have to think about, like, we have a lot of power. The art market has a lot of power in determining the value of these works, and there are just other factors at play beyond copyright. So as Franklin said, we should all be educated and make our voices heard. So thank you everyone for joining us today. Really appreciate it. Thank you. And you could watch the replay of this on our LinkedIn page. Thanks. Bye.